Good morning, Miss Grief. A couple of points before we start. We're being live streamed, so will everybody be particularly careful about identification of the family? I propose, Miss Grief, that in our judgments we should not refer to the employment of the father or where they live.
Yes.
So I don't see any need for that to be referred to either in the judgment, in submissions. All right? It's very difficult not to name the child in these circumstances, but let's all do our best to avoid that.
Well, thank you. And the transcript of judgment has allocated an initial for the child.
I was going to propose to use the same.
And I will try to use that or just the child.
Yeah, I mean, thank you. Second point is this: have you had a chance to discuss with your colleagues the division of time today?
Well, we haven't discussed the division of time, no.
Well, we've got to finish it today, Miss Grief. So, what's your proposal?
My proposal is, I imagine I would probably be about an hour and a half.
Okay, that sounds good. I think I would then want to hear from Mr. Bickler, as Mr. Bickler supporting the. I assume there's been no change in anybody's. Has there been any change in any positions since the skeletons were filed?
No.
Well, then I think you should go next, Mr.
Yes,
Bickler.
my lord. We had discussed that at the bar and reached the same view.
And then Mr. Fian and Miss Worsdale. All right, thank you very much. So we have read quite a lot in this case. We've read the judgments, read your skeletons. We've dipped into some of the other material as well. We don't have transcripts of any of the evidence, do we, in this case?
We do not. And my lord,
I'm sorry, we don't have the evidence of Dr. Chawla.
Yes. My lord...
If I pronounced the name correctly.
Chawla, I believe.
Chawla,
is
forgive
the
me.
pronunciation. My lord, yes. My lord will note that the document filed on my behalf was quoting directly from the judgment.
Yeah.
And I was content to...
Well, at least I think it's Mr. Fian's document that refers to notes that his junior... Don't worry, I'm not going to... No criticism there, Mr.
No, I followed, in fact, Miss Grief's lead because she quoted her own junior's notes in part of her skeleton.
Okay, fine.
So,
I mean, it's just... It inevitably... I don't know what we'll have to cross that bridge when we get to it. Let's see. All right. Thank you.
it goes to a relatively narrow point as far as we're concerned, my lord.
Yeah, but it's probably maybe quite important for Miss Grief. All right. Yes. Oh, now on the fresh evidence issue.
Yes.
It's not. It was quite striking when I first read it when I was thinking about permission to appeal, but having read the whole thing now, Miss Grief, it's not at the forefront of your case, is it really?
It's not at the forefront of my case. It clearly is a matter that we say would have gone to credibility.
Yeah.
It is a matter which the judge was therefore deprived of considering. And given the criticisms that we make of the lack of analysis in relation to the father as perpetrator, it is my respectful submission that it is reasonable to infer that had the judge had that piece of evidence and tried to reconcile it with the father's answers, namely that number one, he was not angry or frustrated.
Yeah, okay.
Two, that he was only speaking out of concern. And three, his denial that it was in any way jocular.
Okay. Well, it's part of your case that the judge didn't consider the father's earlier reactions when she came to look at the evidence the 3rd to 5th of December.
Yes.
Yes. Well, I think what we'll do is we'll hear argument on it and decide what to do and look at it de bene esse. That's what we'll do. So, but I don't think this is something we should take a lot of time on.
Does my lord wish me to address that now, or in fact go to the substantive grounds?
For my part, I'd rather go straight to the substantive grounds
perfectly
and then say what you want to say. In addition, you say quite a lot about it.
Indeed.
I don't know that you've also quite a lot about it. I don't think I don't think we probably need to hear much more on it,
No.
if I say so. And I think we'd rather go to the substantive grounds.
Thank you. No, I noticed that I haven't introduced.
No, sorry.
But
I've jumped in. Forgive me.
but I probably ought to.
Yeah.
So in this matter, I appear to represent the appellant mother.
Ms. Keithley.
Together, yeah, indeed, and the first respondent, local authority, who I shall not name, is represented by my learned friend, Mr. Finn of King's Counsel, who in turn leads Miss Oakley, who was junior counsel at the hearing in York. The father in this case is represented by my learned friend, Miss Worsley of King's Counsel, who in turn leads Mr. Latham, both of whom were at that hearing jointly together. And the child with whom we're concerned, through their children's guardian, is represented by Mr. Bickler of King's Counsel, who in turn leads Ms. Mason, who was the leading junior for the guardian at the hearing in York.
Yeah.
My lord, this matter comes before the court by way of an application for permission to appeal, which indeed came before my lord on the papers, and he granted permission on all grounds. On the 19th of June, I believe, although the date of the issue is the 20th of June.
Before you get going, can I just ask one other thing so it's clear in my mind? If we allow the appeal, are you all agreed about what should happen?
We haven't discussed it.
What's your view?
My view is that we would inevitably, I'm afraid, have to have a rehearing.
Well, I assume, okay. I think, yeah, you're not asking for this court to substitute
No, thank you.
anything else. Thank you.
I think given the way that I've argued the case, I don't think it would be appropriate for me to do so.
Okay, right.
Thank you. So, my lord, can I start by taking the plunge straight into the legal principles which are set out in great detail in the other parties' documents, namely the local authorities and the fathers, and deal with them head on?
Okay. You mean when we're talking about Phage and Volpe?
Indeed.
You can rest assured, Ms. Grief, that we're very familiar with those authorities.
Indeed.
They arise in nearly every case, not just in family cases.
Indeed.
They
And
arise in other areas of the law.
indeed. And for my part, I simply wanted to hone my preliminary submissions in this way. That we readily accept that the judge is not required to set out ad nauseum all pieces of evidence that have been adduced or considered. And the judge does not have to deal with every argument presented by counsel. But the reason that we say in this case that the judge's decision was rationally unsupportable is based on two central propositions. The first proposition, my lord, is that we submit that the judge demonstrably failed to consider and weigh the evidence that would point towards the father being the perpetrator. And quite perversely for my own case, in some senses didn't do that for the mother either. And that's linked to the second proposition that I'll come to in a moment. And therefore the challenge to the judgment in this case is not about the failure to mention one or more pieces of evidence. It is about the failure, we say, of the process of whatever is mentioned, or indeed in the judge's mind, to set it before herself and to set it before the parties and in the judgment, how those pieces of evidence were balanced against one another. And we say it is that fundamental lack of process, looking at factors that pointed towards the father being a perpetrator and indeed against, towards the mother being a perpetrator and indeed against, balancing them holistically against one another, deciding what weight is ascribed to factors, to seeing then, if it's possible, to reach on the balance of probabilities the determination that one of those two carers was the perpetrator on the balance of probabilities. And we say that in this judgment, the nearest that the judge came to it, really, was at paragraph 96 of her judgment, which I don't need to take you to right.
96.
96.
Right.
But I only raise it merely because she accepts that it was apparent that the father had the opportunity to cause friction. And we say that this is where the problem has unfolded in this case. Because in our submission, the judge was taken down a route towards an event, and this is the second part of our proposition.
This is number 2, is it?
Yes. That the judge took a linear approach to the evidence, in which she adopted a line of analysis, in which she focused on what the mother would have heard or must have done on the night of the 3rd of December. And she worked backwards. And we say that the entire analysis has been filtered through the prism of starting at the end and working backwards. And the consequence of that, we say, is that by reaching a decision which we say in and of itself is not rationally supportable on the evidence, it was then used as a yardstick from which to discard consideration of the father at earlier points within the sequence. And the third proposition is that underpinning this analysis and approach appears to be an assumption which we say is not based on the evidence, that injuries could not have occurred when both adults were in the home.
You used to say there's a presumption.
Yes.
The presumption.
Yes. And in taking that approach, and we develop this later in the document, it is our respectful submission that the judge then failed to weigh the evidence of Dr. Trawler. As quoted, I don't need to get into the semantics of what else might have been said in some different way in cross-examination, but what was actually in the judge's mind.
Good, yeah. You're content to rest
Completely.
the principal case on what the judge said Dr. Trawler had said.
Indeed, because that must be, as a matter of logic, what was operating in the judge's mind, or should have been. And therefore, given that analysis, we respectfully suggest that unfortunately the judge has driven herself down into a funnel, in effect, in which she has hung on to the idea that she can unlock the entire case by looking at the 3rd of December and working backwards. And we do say that there is an issue of principle in how, in these very difficult cases, judges should be weighing the evidence. And if I may take my Lord's pleas firstly to the authorities bundle and the authority of Re A, which starts at A21.
This is Lord Justice Peter Jackson.
No, this is the judgment
Oh,
of
right.
late Justice.
Alleged again, this is the...
Yes.
Yeah.
And of course, this has been marked for other reasons, just as background for those that may be interested in
The straining point.
the straining point. But I particularly wanted to take my Lords to paragraph 40, only en route to say that I don't suggest that the judge didn't spend a good deal of time thinking about her decision. I don't suggest that she didn't take 6 days and write notes and come prepared. This is not one of those cases. It is whether or not the way that she has gone. Yes.
Not like another case I did.
Indeed, a very recent case. This is a judge who did take her time, but we say, unfortunately, took, to use the phrase, the wrong direction.
Started in the wrong place. Is that how you put
Yes. And when one looks paragraph 42 in Re A. Lady Justice King in that case was considering how the judge had set out the appropriate steps, that is, the questions to which the mind must be directed as per Re B, and Lord Justice Peter Jackson's helpful list. But what Lady Justice King says at paragraph 42 is that the judge completed the first steps in that he properly identified the individuals on the list as the only individuals who could have caused the injuries were the parents. But unfortunately, rather than moving on to consider whether the mother or father had, on the balance of probability, inflicted earlier injuries, the judge approached it from the other end of the telescope. Namely, was it so improbable that the father had inflicted the older injuries that he should be excluded as a possible perpetrator? Now, I accept as a proposition that was the wrong test, that one doesn't assert whether or not somebody can be excluded as a perpetrator. But at paragraph 44, Her Ladyship then develops the point, and that in her judgment, the judge's approach, that it was inherently improbable that there were two perpetrators, was wrong, and goes on to say this. Had the judge considered the evidence against each parent individually, rather than considering whether it's so improbable that the father had inflicted the older injuries such that he should be excluded, that submission would have found its proper place in the analysis. And it is that weighing through the evidence that has not taken place, we say, in this case. And the second authority I simply wanted to take the court to, if I may, is Re S. This is Lord Justice Peter Jackson.
Yes.
In this case, two potential perpetrators, a judge not having reasoned why an accident was not the cause, keeping both parents in the pool of, both carers I should say, sorry, in the pool of perpetrators. And if one looks at A44, where the analysis unfolds, whilst at paragraph 33, His Lordship set out that there needed to be as much clarity as possible about what had happened to S, the child. Goes on to say there is no attempt by the judge to reason why there had not been an accident.
So which paragraph are you at?
33, my lord.
Forgive me. Thank you. Yeah.
There is no attempt by the judge to reason why there had not been an accident. She simply asserts it. But he then goes on to express the finding that she made. They were both in the flat with him at the time the injuries occurred. They both lied. They're both protecting each other. That takes one nowhere. What was required was analysis of the factors that pointed towards and away from each adult as being the perpetrator. If the result was an inability to identify, so be it, but the attempt had to be made. And it is that fundamental flaw, we say, that has taken this judge in the wrong direction.
So how would you characterise in one or two sentences what the judge did that was different from what Lord Justice Peter Jackson was prescribing in this case?
Having taken herself to the 3rd of December and drawn conclusions about what the mother would have heard and would have done, she ignored relevant evidence that she needed to consider to weigh in the balance as to whether or not the perpetrator of the earlier injuries, that is 2 sets of rib injuries, could have in fact been the father. And so what did not happen was, for want of a better phrase, the balance sheet, in which the court is considering what the mother might have heard, should have heard, could have heard. And I'll come to why we say that was flawed shortly.
Was that the correct starting point?
No, in my respectful submission.
Where do you say the starting point?
The starting point, in my respectful submission, was to consider each of the windows, fracture windows, to consider the evidence about each parent in those periods of time and consider whether or not there was evidence that pointed towards or away one or other parent being the perpetrator of those injuries. And this linear analysis, focusing only on the 3rd of December, has constrained the judge in such a way that she then simply ignored, we say, pertinent evidence.
Well, the judge was faced with a case where both parents were blaming the other, but saying it's not me.
Yes.
So, as she said, one of them was not telling the truth. One approach in terms of starting point was to look at the extraneous evidence that didn't turn on what the parents individually said, which obviously she considered. But what do you say about her treatment of that?
Is my lord referring to the evidence of Dr. Chawler?
Well, there's evidence of Dr. Chawler. There's also the evidence of what happened, the agreed evidence, but what happened when the father arrived home on the 3rd.
Yes.
But you're going to come to that.
I can deal with it now if my lord wishes.
I don't want to steer you off course.
Perfectly content to take whatever course assists the court.
Could you just help us as to what... There was a video evidence, wasn't there?
There was.
How many pieces of video evidence?
There was one piece of video evidence that related to the 3rd of December.
And there was another piece relating to another date later. Was it the 4th?
Fifth.
5th. The 5th. Okay.
The evidence does my lord wish me to address the 3rd of December?
At some point, yes. The video. I'm not clear in my mind what exactly that was.
I can assist my lord with that,
Yeah.
if that helps at this stage. The
Just before you do, just to put it into context, I think what, in a sense, my lord's been asking you and I asked you is, your submission, as I understand it, is that the judge should have focused on the 3 fracture windows.
yes.
I'd like at some point you to address which of those windows was most relevant or potent in terms of the evidence going either way, because they are, I think, to my mind, not necessarily the same. I appreciate the judge should have looked at all 3, you say, but the judge has to start somewhere. Which of the windows do you say is the most relevant, the most weighty evidence? And of the reason my lord, I think, is asking you the questions is whether any of the windows has more objectively ascertainable evidence in relation to it. Is that the right point for a judge to start?
In terms of objective evidence, each of the 2 windows that were cited in relation to the potential for the father to be a perpetrator, which were not considered by the judge, related to the night of the 18th to the 19th of November, and then to the potentially 24th of November during the day, and the 25th of November when the mother was out of the house, leading to a hospitalisation on the 26th. So they were 2, we say, potent windows in which there was relevant evidence about the child's presentation, which could be calibrated against the evidence of Dr. Chawler and cause the court to ask itself the question whether or not that was a time at which the father inflicted the fractures. That question was not asked by the judge. The closest the judge got to that question was in relation to the 25th of November and the father being alone for 40 to 45 minutes and a single sentence, considering that that was not long enough for him to lose his temper, without any reasoning as to why.
Well, following up what Laura said, the judge. What do you say to suggest that the window to focus to start with is the last window, the window of the 3rd to the 5th?
If a judge chooses to start at an end point, the analysis must inevitably be weighed against the other pieces of evidence.
Okay, so you start. It's all right to start there, but you can't finish there.
You can't start and finish, and you can't wrap it in a bubble and then push away that which might undermine it.
You can't say, I'm satisfied he must have done the 3rd of December, therefore he must have done the other ones.
Yes.
You've got to say, I think he's done the 3rd of December, let me just check. If he hasn't done the other two as well, or if he has done the other two as well, that will reinforce or weaken the conclusion. But you can't just say that box in isolation.
Indeed. And
Wait, yeah, okay. Thank you.
And it's the re-T point, the then President, Lady Butler-Sloss, in which she was talking about weighing, not compartmentalising, and weighing. And it seems trite, but it's very easy in a very difficult case. And I do say I have some sympathy for this judge, because, in fact, I think I said that to her in all submissions at the end, because right at the last moment, the local authority had changed their opinion, their approach. The Guardian was fully supporting the approach at that point, and there was an inexorable drive. I think I described it in all submissions as the presentation of something simple in a box that you can just put the lid on and it will solve everything.
I mean, if you could, if the objective evidence was so overwhelming that it just couldn't have been anyone other than A, B was actually out of the country, would you say that's not this case?
Of course.
Because it just wasn't. It was a number of factors of usual practice, what you thought you might have heard in the house. And in those circumstances, you say you can't have enough objective evidence.
Indeed. Indeed. And it brings to mind the old authority, I think it's CB and JB, moons ago, in which 13 psychologists and psychiatrists paraded through the court in order to say who they thought was the most probable perpetrator. And it transpired that he hadn't been in the house at the relevant time. Yeah. That would be a classic example in which that objective evidence finishes that point. So I don't suggest that the judge can't do it. There may be a point at which one reaches such clear evidence, but when there are multiple injuries and there are two potential perpetrators, and one is asking oneself, what distinguishes these two between them? And I don't for a moment seek to undermine my Lord's Lord Justice Peter Jackson's analysis that one strives to see, first of all, can I find the perpetrator, and if not, is there a real possibility? And but on the route to getting there, it is my respectful submission that the judge is weighing real possibilities. Because if, in fact, for example, the earlier two rib fractures fitted, and we say they do, fitted with the medical evidence, like a glove, in terms of what the mother was hearing, in terms of an escalation of crying, bring the child to me. The 24th of November, just bring him to me, pleading with the father in the text messages. Then however much one might think, I find it hard to imagine that this mother asleep wouldn't wake up when her child's leg was broken. One then has to think to oneself, but I also have some very compelling evidence over here about these ribs. And so I have to put them in the balance.
The other thing is the reason why the judge thought that the father was upstairs was because it was usual practice.
Yes.
Neither of them had said that. No. And if you're saying, well, hold on a moment, usual practice may not be enough in this case, because look at what has happened on earlier occasion.
Indeed.
To give an example of what you would say.
Indeed, and in my submission, and with the greatest respect to this judge, that is a classic example of a finding made to fit the hypothesis. Because if he were downstairs, it complicates matters. And it is, in my respect submission, I think we deal with this in our ground 4.
Yes.
It is nonsensical on the father's own evidence that this child was unsettled and virtually didn't sleep through the night, and yet he was sitting next to the mother, apparently slumbering away, completely oblivious to it. So as a matter of just plain logic, that doesn't make any sense. And so that was a good example of things that got in the way of the linear approach that then had to be pushed to one side. And in my respect submission, the same applies to our ground in relation to the 25th of November, which is our ground 5, in which...
Yeah. I asked you about the could you just... The judge saw the evidence of the videos on the 3rd and the 5th, did she?
She only saw the evidence of a video on the 3rd.
Okay.
Yes.
And this video showed the child in a buggy or car seat?
In a car seat on a frame.
Okay. And when was there evidence, clear evidence, agreed evidence about when the child was put in the seat?
The only evidence that we can narrow it down to was the father's arrival home at 2:20-ish, 2:30, and they were had gone out and were out in the town by 2:57.
Yes, but was it agreed that the child was put into the seat after the father returned?
I don't know whether... I don't think any evidence was adduced one way or the other about that.
Okay. Right.
Is that paragraph 126 of the judgment? Yes, okay.
Just,
Yes.
106 and 126 of the judgment.
106 and 206.
Sorry, go.
Yes.
106.
106, my lord,
Right.
which is... The leg fracture. The mother argues that the father injured B's leg overnight. She says the video taken on the way to Boots with B in the pram shows that he was fine when the father came home from work that day. And then at paragraph 126, judge makes a finding about it. Doesn't assist me. It's extremely short, I think 20 seconds or so, and although the child's chubby cheeks are jiggling, I'm not satisfied that the ground he's travelling over is uneven enough to disturb his leg, which appears likely to be well wrapped up in winter wear.
You make a point in your skeleton argument that if the judge's finding were correct, that this was a child that at that time had a broken leg.
Indeed.
And would have had to have been dressed and put into the car seat or pram. I think whether it's described as a car seat or pram, it's a seat on a frame. And you say that that's an important piece of analysis or evidence which the judge didn't deal with. That's right.
Yes. And in fact, what we say about it in general is that by the judge's analysis of having to elongate the time at which, from Dr. Chawler's evidence, elongate the time, the further one does that, the less reliable it is. And therefore, as a matter of logic, in order to be close to Dr. Chawler's timing, this must have been proximate to the father returning home. And he gives no account of returning on the 3rd of December, this child being taken out of the house, walked and jiggled on the bumpy, it's the paving stones that have the circles, so being jiggled, which was akin to how he had been described by the judge on the 5th of December, where he'd been extremely unsettled all day out in town, and particularly going over cobbles. So there was, one can start to have some semantic speculation about were the cobbles more raised, but one simply can't take that approach. One has to start to think, if a judge is looking at pieces of evidence that help her understand, what does she garner and how does she treat them? And the fact...
Was there evidence about what happened when there was no evidence about the child after they got home being on the 3rd, being taken out of the seat or taken out of the coat. There was nothing about that.
We know that he was, as a matter of
Yes.
fact, but there was no evidence, for example, that from the father, for example, saying, I was very worried about the way he was.
Well, there was no evidence either way on that, as I understand it. It wasn't. No questions were asked of the parents. Well, what happened? What happened when they got back?
No.
From that trip. Okay, so.
But what was indeed, but what was clear from the father's evidence, that on the judge's analysis, he has arrived home proximate to a displaced long bone fracture.
The judge is finding that when the father got home, the child at some point, not clear when, but shortly that day, we don't know when, the child had been fractured by the mother.
Yes. And
sorry.
No, sorry, please do.
Even reading what she's, I'm trying to work out what the judge had in mind. She's decided already that the child was downstairs, not upstairs, on the Friday night and so on. And then she looks at the evidence of the other factors that might negate the lack of evidence against the father. But what does 126A actually show? She doesn't find that the video assists her in the way suggested, showing that his leg could not then already have been injured, i.e. that the injury might have happened before the father came home. It's short, that's fair enough. 20 seconds or so, and although B's chubby cheeks are jiggling, I think there she's referring to an indication that the baby's being moved around in the seat on the frame.
Yes.
And then she says, I'm not satisfied that the ground he's travelling over is uneven enough to disturb his leg, which is well wrapped up. But all she's looking there, it seems, is in that 20 seconds, can I see any evidence that he was okay as opposed to not being okay, and I can't. But you say, if I understand you correctly, that there's a wider thing to look at. Why didn't the father notice anything?
Yes.
Why didn't it appear when he was put into the winter wrap? Why didn't it appear when he was taken out? And you're saying, I was wrong to say, in that 20 seconds, can I see him crying? Because the question is, looking at everything as a whole, not as something to contradict the assumptions that have been made, but as part of trying to piece it together. That's your case, is it?
Indeed, as part of the jigsaw of pulling together the separate strands in order to build a picture.
Yeah.
And I think I've already said this and therefore don't want to repeat, that this is jettisoned. It is a factor that's put away because it doesn't fit the hypothesis.
But it doesn't cover everything either. It's only looking at 20 seconds. It's looking at, well, how did he get into it? How did he get out of it?
Indeed.
There doesn't seem to be anything else. Is there anything else in the judgment about what the father said or didn't say about the child's presentation after he came home?
No.
Was there evidence about? Were they asked? Was it in their written evidence, or was it asked of them in oral evidence? The parents. How was the child on the third?
There had been evidence about that. The father's evidence was concentrating on when he was caring alone. There was an absence of, I was concerned when I got back. So
when you say there was an absence,
yes.
Was there no evidence about it, or was there positive evidence, as it were, that he'd not been concerned?
I think it's the absence of evidence, in the sense that he was not suggesting that there was anything out of the ordinary or that caused him concern. And indeed, the judge went on to make a finding about that. But the finding in relation to that, I'm sorry to say, I think is part of the package that takes place in this analysis. I have found that it can't be him because the mother would have heard. It's utterly confounding that he didn't notice the leg. Therefore, I'm going to find that he failed to meet the child's needs by not noticing. And there's a real circularity to that, because actually...
Just say that again. I was mesmerised by listening to it. Just say it again.
I'll try to...
Skillful advocacy, Miss Grief.
I'll see if I can repeat it as best I can.
Okay.
The judge's finding was that the father had failed to notice the child was injured. She makes a finding that he therefore failed to meet his needs. Not that he failed to protect, but that he failed to meet his needs. Because the evidence of Dr. Chawla was that she would have expected a parent to notice. The yawning chasm in that analysis is there might be a very good reason why a perpetrator of injuries pretends that they have seen nothing, they know nothing, and everything seemed fine. That doesn't feature at all in the judge's analysis. And therefore, for our part, this finding, such as it is a finding to explain away that which otherwise should be held in the balance.
Could you just take us to where the judge makes that finding?
I can.
And any passages in the judgment which lead up to that? The findings at the end.
Paragraph 145.
Yeah. You don't worry about the
But
first
perhaps
bit.
the lead up to assist my lords in this respect is paragraph 140, probably, at S5 at 23.
140.
Yes. Where she's dealing with the findings about failing to seek medical attention. My finding about when the leg fracture was caused means that the mother must have known all through the weekend that she had hurt B's leg. I'm sure that there was decreased movement of his leg, as Dr. Chawler described, and that the mother did notice this, as Dr. Chawler said a carer would, and that she has not been truthful about that.
Right.
She goes on to explain the mother dearly loves the child,
Yes.
and so on. And then really there is nothing else until we reach paragraph 145 in relation to the father, and make the findings. First one is based on his own acceptance about his behaviour. There we have the inconsiderate and the pestering sexual demands. He didn't support the mother. And then secondly, following on from my findings about the weekend of 3, 4, 5 December, I find on the balance of probabilities, the father failed to notice on 3, 4 or 5 December that B's leg had been harmed. He did not notice the decreased movement which was present. In this respect, father failed to meet B's needs.
So wait, just what you said there was a. Finish it off the point. Why is that a wrong approach?
Because the finding is, in my submission, an ex post facto rationalisation to support the hypothesis, because it's an anomaly otherwise. How is it that this acutely fractured, displaced, fractured leg, happening shortly before the father arrives home, where he is the sole carer of the child, all through the night, is not noticed by him? And one obvious answer to that is because it wasn't broken at that time. And at the time
if it became broken later, he
Indeed.
did it, and of course he'd want to say, you would say, I saw nothing, because
Indeed.
Okay. So I want to get this precise right. You ask, how is it the father failed to notice that there was something wrong all the time he was caring for the child through the night?
Yes. And this finding is a statement of fact. He failed to notice. There are other matters within the judgment about the father being immature. There are other matters in the judgment about the father being preoccupied with his occupation. But the judge nowhere makes findings that this hands-on father, who was the sole carer from newborn for the first 2 weeks of the child's life, and continued readily to be involved, could have missed this. It's also right to say that the mother herself also did not notice anything on her evidence until she saw the swelling and was rubbing the leg and thought it looked different and called the father to say...
That's on the 5th.
Yes, on the 5th.
At 4...
But, sorry, I thought that, I'm looking at paragraph 95,
Yes.
there was agreement that the baby was unsettled over the weekend of the 4th and 5th.
Yes, but that's not the same as... It does, my lord, mean in distinction to the immediate return home on the 3rd.
So I thought you were saying that you were dealing with the question of what evidence there was from both parents as to the baby's state over the weekend. And we were focusing a moment ago on whether the father noticed the fractured leg or not.
Yes.
And you said, I think there was no evidence specifically from the mother either.
That's right.
But I'm pointing out that the one thing they were agreed on is that the baby was very unsettled over the weekend. I'm just looking at over the weekend, or very unsettled that weekend.
Indeed, the wording at the third line down is during the following weekend. 4th and 5th, the family were together throughout. Both parents agree that B was very unsettled that weekend, especially when he was in his pram going over the cobbles on the trip on the 5th of December.
And we know that the baby was presented at hospital on the 6th.
That's right.
4 o'clock.
At 4 o'clock, yes, p.m.
With a broken leg.
Yes.
And that was timed or dated by the medical evidence with a degree of approximation to 70, within a window of 72 hours.
Yes. The judge's phrase of Dr. Chawler's evidence, no more than 72 hours before.
And it's 72 hours before precisely what? What part of the examination?
The pain response.
The pain...
So there is a real
before
distinction
pain
to be drawn here between two parts of Dr. Chawler's evidence. The first is in relation to swelling.
Yeah.
And...
swelling 48 hours.
Yes, which... I'm so sorry.
No, go on.
Which the judge described as, using Dr. Chawler's note of evidence, variable. And I take no issue with that
And
whatsoever.
Mr. Feehan makes the point that the fact that it wasn't seen before 5 o'clock, 4 o'clock on the
Sunday.
5th
Sunday the 5th, yes.
doesn't mean that's where you start dating back from, because it could have been there because the child was clothed at an earlier point on that day, which would have pushed on that as it were measurement coordinate, would have pushed it back to earlier period on the 3rd.
Well, with respect to Mr. Feehan, I don't quite agree with that for this reason. What Dr. Chawler is referring to is a process. So swelling and it doesn't become in that state instantaneously. So the timing that she was giving was that up to 48 hours it would be consistent. Seeing it at that point on the 5th, up to 48 hours before would be the time for injury. But I don't hang my hat on that.
No.
For the simple reason that Dr. Chawler said swelling can be variable.
Yeah.
Indeed, sometimes there is no swelling at all. So I don't hang my hat on that. But I do say that the evidence in relation to the pain response, which was still elicited at the hospital at 1600 hours on the 6th of December, in which Dr. Chawler, as summarised by the judge, said up no more than 72 hours.
No more than 72 hours before the 4 o'clock.
Indeed. Indeed. And the reason that I hang my hat on that more clearly is because Dr. Chawler was pressed regarding...
Yes.
Can we not narrow that down? And she was giving that outside window and would not shift. Quite understandable.
Well,
Not
this
a
is where I ideally like to see her evidence transcribed, because did she? How specific was she about the 72 hours? And what did she say? Well, I won't speculate what she may have said, but I can imagine that she may have put it differently. So it's quite.
It is nuanced because she was asked questions by 4 different sets of advocates, but the end point in re-examination was I won't shift down, but my limit is no more than 72 hours, which is where the judge has lifted no more than 72 hours from. So,
Well, even the judge recognises that a 1-2-4, her timing, the judge's timing, requires some extension of the 72-hour time frame, but only by a few hours. And she says that seems valid to me, given the variability of a child's reactions. I'm not sure what that's a reference to. It's not a reference to the evidence that Dr. Charlworth has.
I think it's a conflated reference to variability in relation to swelling, as opposed to the expected and anticipated pain reaction, which was the 72-hour timing. And it's for that reason that I say it's important that they are separated out. Just on that notion, I don't wish to take up too much time in relation to this, but the document that we prepared, in which we set out the grounds that the judge had failed to consider 72 hours at all, was taken from the agreed note of the judge's judgment, which was all I had when I prepared my document. The others were lucky enough to have a transcript. The judge now has in both timings, if we look at 124, exactly where we are. But it doesn't change the point, but it just means that when one's considering the skeleton argument that we put in, and we said that she failed to consider 72 altogether, 72 has now been added. I do not know whether that is by the transcribers or whether or not that is by the judge when she was...
Well, the judge is entitled to do that.
Indeed, but I wanted to explain why I had couched it in the terms that I had.
Okay.
It doesn't change the point, but it would be wrong for me not to bring that forward.
But you will say that on the judge's own reasoning, she recognises that it's outside the time.
Yes.
And then you've got he must have been upstairs, not downstairs.
Yes, that's
right, because of common practice. And the objective evidence, you say, seems to contradict that. Neither of them could remember what happened, so it's common practice. You say they haven't looked at everything else, and you say on top of that, that would require, as the judge recognises, a departure from the evidence. So the judge's basing it on common practice. When that's a departure from objective evidence, is the way you put it, really.
Yes, and we said that that wasn't justified on the judge's single sentence in paragraph 124, given the variability of a child's reactions, without weighing it with the other piece of evidence that we've already been through. And this, I'm afraid, is one of those anomalies that are in the way of the hypothesis, and they are therefore explained away.
Right. And just make sure I've understood that submission. You say that what she's done is arrived at the hypothesis and explained away the anomaly, when what she ought to have done was to weigh the points raised under the hypothesis against or alongside what the contrary evidence before reaching her decision.
Indeed. A holistic balancing of the evidence, not compartmentalising the evidence, and looking, as precisely as my Lord Justice Peter Jackson said, evidence that goes for and against. And that is why in our grounds 1 and 2, I don't need slavishly to take my Lords through the document, but in our grounds 1 and 2, we deal expressly with the judge's failure to recognise the benefit of a piece of evidence that may help her in her decision. So when, for example, I'm looking now at our ground 1, which is paragraph 24 of our document, which is F2, page 10. Little a. This feeds in precisely to this point. And the vital piece of evidence that we say that was ignored at that point was the reliance by the judge in her analysis that the mother would have heard, because she would have called for the child, she would have woken, she would have called for the child, because she'd done so previously. And she cites the example here. That very example that she cites was a clear opportunity within the fracture window when the father was alone with the child downstairs, including one of them during the day, where the mother could hear her own words, an escalation of the crying, which is precisely what Dr. Chawler said in her evidence, was the likely scenario. And if we take a moment just to refresh our memories in the judgment, that is at S5, paragraph 13.
Okay.
We can see there how Dr. Chawler,
Sorry, S5.
13, my lord.
Sorry, not paragraph 13.
No, sorry, page 13.
Page 13.
And once we're there,
Yep.
Dr. Chawler's evidence is dealt with from paragraph 65 onwards. But if you have a look, please, at paragraph 69, she was asked about concepts of different cries and whether or not there would be a change in cry, and that, as it were, being momentary. I don't for a moment suggest that that meant there was a sudden momentary cry and nothing else. And I set out in our skeleton that Dr. Chawler went on to describe it would be pain and distress for 30 minutes, to an hour, even potentially 2 hours. But what is clear here is that Dr. Chawler was describing in circumstances where a child, if we have a look at paragraph 72, just over the page 14, later in her evidence she said, a person not observing the causing of the fracture, but in the same house, would be aware of an escalation in the crying, but may not know why.
Was Dr. Chawler asked to view the video and express any view upon the video taken on the 3rd of December?
No, there was a request made for Dr. Chawler to see the video of the winding, which she described as very intense. But the video was not submitted to Dr. Chawler.
That's a different video.
It is.
I'm asking specifically about. See, I'm looking at paragraph 126 of the judgment, 126A, which the judge relies upon, she says, to make a finding against the mother.
Yes.
But in fact, 126A is, I think, saying, in reality, I don't get anything from that video. I'm not sure why she's relying on it to make a finding against the mother, other than by process.
Yes.
But the judge's view is that video of the child on the 3rd of December, and I think we know it's about 2:57.
Yes.
Is that right, in the afternoon?
It is.
The issue she was dealing with is your point that you reiterate on appeal, which is that doesn't appear to show a baby suffering from a leg fracture.
No.
And the question is whether Dr. Chawler was asked to express a view about that, which you would have thought, given all the views she's being asked to express about babies crying and how they react to the pain reaction to a leg fracture. I'm surprised she wasn't asked to view that video.
Yes. With hindsight, it probably would have been preferable if she had.
But the answer is no.
The answer is no, she was not shown the video. And one has to also, I think, remember this issue arose during cross-examination of the mother. So at the end of the process, in which it was being asserted by the father that he had not attended Boots and wasn't home till much later, and so on and so forth. And the mother then spontaneously said, but I've got a video. And we went together, and she looked back on it and saw it was light, so it allowed her to know what time, given that it was the winter, deep winter. So it arose in that way, as opposed to, here's a piece of evidence that we'd like the expert to consider, as it were, at the beginning of the process.
Okay. All right. You've taken us to 125, and
Yes?
what that seems to show that the reason the judge reached her finding was the lack of evidence against the father in the time period.
Yes.
And then she says, in addition to that, I take into account the following matters.
Yes.
Well, she doesn't accept there's anything in what's said in 26A. She doesn't accept the submission you made about alter in 127. It doesn't accept the point you're making in 128 onwards.
Yes.
Okay. So none of those are matters she does rely on in reaching her finding.
No.
It's the lack of evidence against the father in the time period
Yes.
is the reason she makes the finding.
Absolutely.
And in reaching that finding, as she's acknowledged in the previous paragraph, she's had to extend Dr. Trawler's time frames.
Yes. She's had to make a finding based only on the usual practice that flew in the face, we respectfully submit, of the two obvious pieces of evidence, namely, how could they each have such different recollections of how the child presented that night if they were literally sat in a bed together? The mother talking about a very settled night, in my submission, the only logical conclusion, or at least the only logical question, the curiosity for the judge to ask herself, well, what she says is, they give different accounts, so that doesn't help me very much. In my submission, that would be a key to helping. Why is it that they have such different recollections? And the second part of the evidence that she did not take into account was the father then texting at 8:45 in the morning with the feeds that had been done through the night in order for the mother to log them. It's absolutely right that she wanted that to happen.
Yes, it wasn't a one-off, was it?
No.
It was a common practice.
It was a common practice. But as the judge flags, the father would choose not to text until the morning so as not to wake the mother. The judge seeks to rely on that if she gets woken by a text, she must get woken by a crying baby thought process. But doesn't take into account if the father's undertaking a process so as not to wake the mother. Doesn't that feed into the very proposition that the mother is having, as per the agreement between them, her Friday night off, and he is downstairs caring alone on his account, recorded by the judge, as a child that really didn't settle and really didn't sleep very much. So that evidence too was just sidelined. And so by the time we've gone through this process of getting to 125, sorry.
In addition to your point, I just reminded myself that she's also not taking into account the evidence about the other injuries.
Absolutely. And when the judge uses the phrase, the lack of evidence, it is bound up in this self-selection of when was the father alone? When might the father have been able to do this without the mother there? And that presumption, we say, ignores the evidence of Dr. Trawler that with two persons in a household, indeed with them awake, there might be a momentary change in cry. There may already be crying, then there's a sudden momentary change, and then continued pain and distress. But for the non-witnessing, non-perpetrating person in that household, with a child who is deeply unsettled, and sad to say, we have a very good understanding of why now, because he was suffering with these fractures through this period of time. The escalation in the crying, as described by the mother, is precisely fits that evidence as given by Dr. Trawler.
But where's her evidence of the escalation of crime? The mother's evidence.
The judge quotes it, and my lord just gives me a moment.
Okay, come back to it.
Yes.
Perhaps Miss Keithley will find it in a moment. Yes?
115.
No, thank you.
They both talk about escalating at times. 115. Come back to it, Ms.
Thank
Grief, when Ms. Keith has got it.
Yes, thank you. And therefore, exactly the point that my lord raises, having reached this point of the lack of evidence, what the judge was focusing on was, can I say that he injured this child on the 25th of November when the mother was out for 40 to 45 minutes? Answer, I don't think that's long enough for him to get stressed. No reasoning whatsoever in relation to that. And she then works her way through other times when he was on his own for short periods, which was the father's case, and of course the father would put a linear case, why wouldn't he? But it was adopted by the local authority, supported by the guardian, and what the judge was not getting was any balance as to what is pointing one way and what is pointing the other, and how might I weigh them. And so when she talks about a lack of evidence, she means a lack of time when I can say he's on his own and could have carried out these injuries. And that demonstrates, as clearly we say as anything else within this judgment, how the relevant evidence was simply overlooked. And that is the evidence that we've just set out in paragraph 24 a, which is the escalation.
So where you take it 24?
Any of this?
Yes, grounds where we were at paragraph 24 a.
Have you located that evidence about escalation yet? That's what I was asking.
I did.
Where is the evidence about, apart from what's in 115, which is in more general terms, where is the evidence that you're alluding to in 24a? The occasions when the mother had caused the father to bring B to her because of an escalation in B's crying to justify the finding. Ignore that.
My lords, I've got some notes from the judgment itself, and that might be that's the best way for me to find it. Just give me a moment.
And paragraph 91 of the judgment, I think it's S517.
Thank you, Miss Worsley.
It doesn't refer to bring him to me, but it talks about the escalation. It's the 24th of November.
Thank you. Yes. And what we know from the text messages is that the mother was asking father to bring the child to her, which is used in the judge's reasoning in relation to the basis for her deciding on the 3rd of December that the mother would have done that because she had previously done it. And therefore, when she comes to her decision about the 3rd of December, she is using that as a piece of evidence as to why she simply can't accept that the mother would not have heard and would not have therefore asked the child to be brought to her as she had done previously. What she failed to do at that point was then think to herself, there are times when the mother has heard an escalation in crying to the extent that she's asked the father to bring the child to her. Might that be a time when the father had inflicted rib injuries downstairs, such that the mother heard the escalation and called for the child to be brought to her? Well, we've roved over the skeleton in a way that I only want to be able to help my lords, and therefore I think potentially our grounds my lord has.
We've touched on all of your grounds.
We have actually, but at paragraph, I'm just perhaps thinking that in terms of the analysis of not compartmentalising, it really is our paragraph 28 onwards. And indeed, our paragraph 29 at the bottom, where we quote part of the judge's judgment, the initial crying and ensuing crying and distress would have caused the mother to check on B. She frequently got the father to bring B to her when he was crying.
1, 2, 2. It's 1, 2, 2.
Oh, that's what it says, yes, about bringing the baby to her.
Yes. And so we go on at the rest in the remainder of that paragraph to deal with the evidence of Dr. Chawler, which I think.
So yes, Dr. Chawler. Can we look at 1, 2, 2 as we've alighted on it? Thank you very much.
Yes.
Dr. Chawler. All this is Dr. Chawler's evidence, is it?
Yeah.
The leg would have been painful immediately the fractures were caused.
Yes.
It was obvious that something was wrong with reference to decreased movement.
Yes.
The initial cry and ensuing crying distress would have caused, she says the mother, she means the carer at the time. Is she? She must do.
Yes.
She frequently...
No, she doesn't. By this point, this is all part of the mother would have.
Oh, sorry. Well, you see, that's what's confusing me. It's my
Indeed.
fault.
I think it's only the second sentence is Dr. Chawler's evidence. I think the third sentence seems to be the judge's
Yes.
inference of what would have happened if the child was distressed because of the injury.
Yes.
But the last sentence is Dr. Challow, isn't it, again?
Yes.
Or is it the judge's inference of the whole of the evidence?
Well, it's difficult to know, but certainly Dr.
Well-
Chawler's view was that there would be pain on movement. That was definitely Dr. Chawler's
At
evidence.
what point was it Dr. Challows? Does Dr. Challows say at what point there would have been obvious pain? Obvious, would the pain have been apparent if his leg was moved or touched? Is that at all points after the injury, or only in the immediate period after the injury?
As I understand it, it is all points up to the 72 hours, which is where she works.
Is that
back
agreed?
from. I believe so.
Because we don't have Dr. Challows'
No.
evidence. I don't recall that. I've read the report. And the addendum. I don't recall reading that.
Well, no, because and indeed the report and the addendum was superseded by her oral evidence, in which she narrowed the evidence, the timings, as a result of
Well,
cross-examination.
are we to take this last sentence in 122 as what Dr. Chawler said?
Yes. For my part, absolutely.
Well, and if you look at 123, I think 122 is a combination of inferences drawn from a number of different pieces of evidence.
Yes.
Some Dr. Chawler, some what the parties had said.
Yes. And then the last part of 123, rather confusingly, that the fact that there is no evidence of B being in such pain, in pain like Dr. Chawler described, from the point when the father came home, causes me to find on the balance of probabilities he was not injured after the father came home.
I mean, paragraph 66 is where Dr. Chawler's evidence in relation to leg fractures is clearly given.
Yes.
My understanding of Dr. Chawler's evidence was that, putting aside swelling, this is the point you were making earlier,
Yes.
where there is a fracture, there will always be pain on movement. In the middle, that should be obvious, even though the swelling may not be obvious. That's decreased movement.
Yes.
But decreased movement should raise concern when it's... So, in other words, I think it's saying that there are almost certainly clinical signs such as swelling, decreased movement, and pain on movement. She talks about the swelling, she talks about the decreased movement.
Yes.
But my understanding is that she was saying if you move a broken limb, it causes pain.
Yes.
I don't think that's terribly revolutionary.
No. And it is, and the corollary of which is, as part of Dr. Chawler's evidence, was that she would expect a carer to notice decreased movement because the child's natural guarding would be to keep the limb still.
Right. And hence I come back to something which I know you haven't, in a sense, got onto it, but it's in your ground three, I think, which is we have at least some agreement and a piece of objective evidence about the status of the baby on the afternoon of the 3rd, and then, because that's the video, and then evidence which is agreed about the increased unsettled nature of the baby on the 4th and the 5th.
Indeed. And the mother's evidence, which was not challenged,
Okay.
for half part
Why-
on the 3rd. Sorry.
You've placed a lot of stress on, for I think fairly obvious reasons, on this question of whether the mother would have woken up or appreciated a cry from a baby if the baby had been injured in the house in which she was with the father on the evening of the night of the 3rd.
Yes.
I mean, that inherently is subject to quite a lot of question marks about, which I think are noted about whether, for example, the mother was asleep, where the couple were, whether the mother was on medication at the time, all sorts of uncertainties where there's no, what I'd call, objective evidence, because the only people who know what was going on in the house overnight on the 3rd are the father and the mother,
Indeed.
giving subjective evidence, by definition one of them not telling the truth, about
Yes.
what was going on.
Yes.
Goes back to the question I started off with. Why is it appropriate for the judge to either start there or for you to be focusing so much of your attention on that question of what the mother would have heard or might have heard if the father had inflicted the injury on the evening of the 3rd? Why shouldn't the judge have started by looking at objective evidence which doesn't depend upon what the mother and the father are saying about what was going on that night?
But no reason at all. And my focus on the 3rd of December is to challenge the judge's focus on the 3rd of December, and her should have heard this is what the mother would have done, and we say respectfully it was all speculation, and for precisely the reasons that my lord has outlined, the myriad of unknowns, and that what the judge needed to do was consider Dr. Chawler's evidence, whether or not she was being told anything about the father's return home that was in any way consistent with an acute fracture at that point. There wasn't. And then work her way through, if she's choosing to start there, work her way through and say, what do I know about overnight? I know that the father tells me the child was unsettled and didn't sleep most of the night, but the mother didn't hear it. And then asking herself, what do I then see or know about the 4th and 5th of December? And the 4th and 5th of December is an agreed approach between both parents that the child was extremely unsettled, even whilst out, particularly even whilst being pushed over the cobbles.
I didn't understand the word extremely. Is that your word or the judge's word?
Well, both parents, for the father, we don't have the transcript of the
I
father's
don't
evidence.
remember the word extreme.
Sounds like your word.
It is my word.
It is.
It is my word.
Right.
But he...
Better to stick to the judge's recital of
Yes,
the evidence. I
yes.
think.
The danger of having the knowledge of the way
What is
the
the
evidence
what is the
unfolded and not a transcript.
well, what's the precise word the judge used? Unsettled.
Very unsettled.
Very uncertain.
Very unsettled. Okay. So so drawing those threads together, we have no evidence that the child was unsettled on the 3rd.
No.
And we have agreed evidence that the child was very unsettled on the 4th, 5th.
Yes.
Your point is that raised a question, or should have raised a question in the judge's mind about the conclusion that she had reached, by whatever route, that the mother had caused the injury prior to the father returning home on the 3rd.
Yes.
And you say if the judge had engaged in the process of weighing evidence, that's a question that she would have asked herself.
Indeed.
Because of the linear approach to the place she started with, she didn't actually perform that exercise.
That's exactly the submission. And it is then compounded by the failure to, that's, as it were, stress testing it within itself. But it is also my submission that any analysis of the 3rd also needed to be stress tested against other opportunities. That doesn't mean opportunity when was the father on his own, but other times when there are behaviours about the child which give rise to the reasonable suggestion that the child had been injured, because we have 2 sets of rib fractures that are separated in time from this leg fracture, and they simply don't feature.
So is the submission that if the judge had looked at those and if there were factors that were pointing one way there, she might have said to herself, all I've actually got is the common practice and no specific evidence, and it's contrary to the objective evidence. When I take into account the other things, I really can't put as much weight as I have done on the common evidence and the common practice, and the fact that the mother would go and pick up the child and would have told me if she knew the child was ill.
Absolutely. And it's that elevating, surveying the canvas of the known injuries in the known windows and weighing those pieces of evidence against one another, where one has a simplistic case of this sort where there are 2 potential perpetrators. What is it that elevates one above the other? And unfortunately, the judge's analysis centred around it couldn't have happened when they were both in the home together. And that's obvious in the way in which this analysis has been undertaken, which is why we get into, you can hear sound travelling from one room to another, and there are thin walls and there are thin doors, and the grandmother heard somebody on the telephone. But they are, if I may say, the stuff of make-weights to allow herself to say, I'm drawing inferences, but actually what was happening was being seduced by the idea that all I need to do is if I find the perpetrator here, then there aren't 2 perpetrators, and therefore that explains the others. And never asking herself, to satisfy myself about the perpetrator on the 3rd, what do I know about perpetrators on the 25th when the father was alone? What do I know about the 24th when there was an escalation in crime that the mother asked the father, please bring the child to me? What do I know about the fact that by the 26th he was refusing feeds? He was crying every time he moved, and therefore he was taken to hospital. What does that tell me about rib fractures? And similarly, with my bare text, forgetting the emoji, we know that the father was downstairs caring for the child alone for a significant period of time. From his arrival home on the 17th, all through the night of the 17th, all through the night of the 18th, into the 19th, at which point he is describing, I've had the morning from hell, he's only just stopped crying, and the mother doesn't know that. And so at that point, that professional curiosity is, well, if I'm thinking about how these separate sets of injuries occurred, what does that tell me about the potential that the father is the perpetrator, pointing for and against, and the potential that it was the mother at some other stage? And of course, by that point, from the 17th through to the 25th, the father is home throughout. And so that ceased to become a fertile ground for the judge, because the fixation on this injury couldn't have happened with them both in the home permeates the thinking and causes highly relevant pieces of evidence to be jettisoned. They may not tip the balance. If this case is reheard, there may be the same finding. There may be a pool finding. there may be the completely opposite finding. This is not about whether or not one can safely look at a piece of evidence and say that must have been the father. It's about the lack of process of weighing it, which makes it irrationally unsupportable, because we've reached a point where the judge has taken such a wrong direction that she was closing her mind in my submission.
Well, I think we have that submission. Now, I've noticed you've had an hour and a half.
Yes.
How are you getting on? What haven't you covered?
My lord, I have a number of matters that I had noted by way of reply within my skeleton. I am more than content to deal with those, as it were, as part of reply, if it would assist.
Well, actually, I think you better, unless they're going to take a very long time, deal with them now, and we'll note them down, and then, because we know the way it goes with submissions, particularly
Yes.
in the Court of Appeal, where we occasionally intervene, is that Mr. Fear may not make the point that you don't want to reply to because he'd be taken on to something else. So why don't you say what you want to say, and we'll just make a note of them rather than perhaps
Yes. May I just?
Responding to them.
A number of them have been dealt with now, so in various ways. Yes, may I just deal, please, with, so it's our paragraph 50.
Right. In your submission.
In our submissions, which is S2, page 20.
Mm-hmm.
This is in relation to the finding that the judge made that on the 25th of November, the 45
In the 45-minute point.
not long enough. Within the father's submissions, so that is still in section 2, but now page 53.
Right.
Paragraph 51.
Mm-hmm.
The last part of that paragraph starts, the judge found that it was unlikely that in 45 minutes the father could have lost control, injured the child, composed himself and settled the child enough for mother, with her attunement to the child's needs, to return and suspect nothing at the time or subsequently when preparing her statements. With the greatest of respect, that is not what the judge found. She found simpliciter, but it wasn't long enough to lose control.
Just show us that, would you?
Yes. And so, yes. You have a look at probably paragraph 136, I think.
So just so Miss Worsley understands, this is.
I'm sorry, I didn't hear you. I didn't hear your last comment. That was.
I said I was trying to. Miss Grief is challenging what you say, so I wanted to know the basis upon which Miss Grief is saying you were wrong. Yeah.
Section 5,
Yeah.
the judgment paragraph at page 23, paragraph 136.
Okay. Yes.
In which she says, I accepted the father has the opportunity to cause fractures, but that's not the same as it being likely that he did so. And again, focusing only again when he's alone, not considering the other times in the 24th or the 25th. On the 25th, while the mother was out, 40 to 45 minutes, I think it is unlikely in that period he would have become so stressed and frustrated as to lose control. Full stop.
I mean, I think the point, what could be said, I see that you say that as the skeleton is put, it goes beyond the judge's actual findings. But in a sense, it's drawing inferences, isn't it, in the sense from the skeleton's point of view, because nobody apparently is suggesting that the mother was concerned about how the baby appeared when she returned home.
When she returned home, the baby was still crying. She did not suspect
What's
that
the
the baby
judge?
had been injured.
Can you show Could you show us what the judge said about how the baby presented when the mother returned home?
Yes, the next sentence. He was crying the whole time. The whole time refers to when she arrived back. So from the moment she left until the moment she came back, the child was crying.
Well, I read that as saying the baby was crying for 40 to 45 minutes, that the father was on his own with the
Yes.
baby,
Yes.
is how I read it.
Yes,
Absolutely.
not after the mother returned.
Not after the mother returned.
So is there a finding by the judge as to the state of the baby when, what the mother observed about the baby when the mother returned home on that day?
The judge refers to him being unsettled.
It may be that actually we should be asking this question of the author of paragraph 51, but I just want to make sure I understand what you say.
Yes, paragraph
The extent of the
91.
judge's final. Sorry.
Paragraph 91, my lord, is where the judge it says Miss Grief highlights and goes on to set out the evidence that the mother gave. It's not, the judge doesn't determine that was false or unreliable.
So you say on any view, whatever findings there are in the judgment, they don't support the proposition that on the mother's return, the baby was settled.
No.
Right.
And indeed, what then took place during that night was him he was unsettled through that night. A health visitor arrived at 12 noon and she was concerned to the level to which he was crying and could not settle.
Which paragraph did you ask? 91?
91, my lord.
Yes.
And therefore, later that day, the child was then refusing to feed. The child was, which was unusual and had not happened before.
Okay.
The child was refusing to feed according to both parents, as recorded in the judgment, and the child was then taken to hospital, and the mother, as recorded in the judgment, was saying, whenever he moves, he seems to cry in pain.
In a way, this almost exemplifies the submission that you're making. You are saying that you can't read the judgment and work out what happened when and whom and what the things were at different stages. So we're struggling to find out on the 25th or whenever it is, what was the baby like before, during and after, and you're saying, well, that's part of the problem. You can't pick it up saying, I see what the position there, I see what the position was 2 weeks later, I see what the position was on the 3rd, and working out everything. It's like little boxes, 1 crying, 2 movement, and so on.
And the reason the boxes were devised was because they were the 4 occasions that were highlighted on the father to run his case of, it couldn't possibly have been me because I haven't been alone with this child sufficiently to have caused the injury the mother would have known. And that is what all of this analysis has been about. And that's why the value of the evidence was missed. The judge didn't see it as a helpful tool. She saw it as, well, the father wasn't there very long, or I don't think he would have got stressed in that period of time, and it's shut away. And we say that that's because of the linear approach that the judge was taking.
Is it right, incidentally, that you stressed, looking at the middle of paragraph 91,
Yes.
that the escalation in crying and the mother texting he's in pain again was on the 24th before the 45 minutes on the 25th?
Yes, when the mother was upstairs, the father was downstairs caring for the child, and that was one of the pieces of evidence which the judge then alighted on to say, well, I've seen the mother call the child up before, she would do it again on the 3rd of December, whereas we say that's the insight for the professional curiosity of might that be when the father then inflicted...
Well, no, yes, but as 91 reads, the escalation in crying and the mother's text precede the father being alone.
Yes, when they're both in the house together, but he had been caring for the child downstairs alone. So yes, but it was a separate occasion when the father was caring alone. But we had.
Yes, I'm just wondering. Sorry,
Sorry.
I'm not making myself clear enough. I'm sorry. I'm just wondering why you were highlighting. You were recorded as having highlighted an escalation in crying and the mother texting he's in pain again, when your case, I understand it, is it's likely that the rib fractures were inflicted on the 25th when the father was alone in the house.
My case was not linked to the 25th for two reasons. One, I didn't have to run a positive case because there was no burden on me. And two, I did not adopt or accept the judge's analysis that one had to focus on when the father was alone in the house.
All right.
Okay.
Yeah, fine.
So you're saying it could have happened when he was on his own with the child, or it could have happened when he was on his own downstairs with the child, or upstairs with the child, you elsewhere in the house. You hear the change in crying, and your client hears the change in crying, and takes he's in pain again.
Yes.
So that's her responding to a cry she hears when she's not present,
Yes.
and infers that it's pain.
Yes. So once that is in the arena on the 24th, and the mother is upstairs and the father is downstairs, and they're in the same household, that fits precisely with Dr. Chawler's evidence that a carer, who is in a household where they're not witnessing, they're non-perpetrating and not witnessing, they may hear an escalation in crying, but not know why.
Well, it is. I mean, your ground 5 is now very firmly focused on criticising the judge for not having made a finding that the rib fractures were likely to have been inflicted on the 25th of November, as I read your ground 5.
Yes, but the ground 5 in relation to the 25th of November is the judge's flawed approach being wrapped up in the linear approach of the 3rd of December and therefore jettisoning with a wholly unsupportable, not unreasoned dismissal of even the possibility.
Yes, but I'm trying to ascertain whether you're now criticising the judge for failing to make a finding that you actually weren't asking or weren't stressing to her at the time.
I stressed to her the 24th or the 25th when the father was alone. They were both options because of the nature of this child who was very unsettled, the nature as described by Dr. Chawler of rib fractures, which are highly non-specific. So the child is crying, but a non-perpetrating, non-witnessing carer wouldn't know why. I did not nail my colours to the mast, and nor did I need to, because I didn't need to prove a case, although sadly the Guardian's submissions suggested that the mother had failed to prove her case that the father had caused the injuries. I don't suppose that helped the judge for a moment. That was paragraph 37 of the
Yeah, well, but yeah, I mean, I don't want to waste time on this, but the submissions you make under ground 5 on pages 20 and 21 do seem to me to focus on the 25th. But I note the way you put it in paragraph 54.
Yes.
Right.
Yes.
Now, what else do you want to respond to, if anything, in advance?
Yes, if I may just check the notes in the margin, I think I've probably...
Well, we'll probably allow you a bit of latitude, Miss Grief. I don't want to jump on you for saying it's... well, that wasn't said in... It wasn't... Mr. Fear won't do that. It wasn't said in sort of proper reply. So, if there are points which it turns out you could have mentioned, Mr. Fear's not going to object.
I think I'm...
I don't expect Miss Worsley will either.
I think by having taken the routes that we have...
I'm sorry.
No, please don't apologise. It's always helpful to know what helps the court, not the other way around. For my part, I don't seek to add anything further at this stage.
Okay. Well, thank you very much.
It'll just be repeating the same points in a different way.
Thank you very much.
Thank you.
Okay, Miss Beck. Quite a lot's been said about the Guardian's support for the local authority by Miss Grief in her submissions. You don't think Unless you want to respond to all that, you need
Yeah,
to respond to that.
As my lord knows, I wasn't instructed at first instance. I was instructed to advise on appeal. A reading of the judgment caused me professionally to...
Well, I don't think we need to know how it's come about.
No.
Right.
It's fairly straightforward. The Guardian did support the findings at first instance. There's no getting away from that. And now the Guardian supports and effectively adopts the submissions that my learned friend Miss Grief has made to you this morning.
Your submissions inevitably are more succinct. That's not a criticism of Miss Grief.
They are.
They are more succinct because you focus in particular on one, as it were, one angle.
Yes.
And use paragraph 5.
Yes.
Which actually pretty much follows what Miss Grief says.
It has. If one looks, Miss Grief made the point that there was a crucial time in this judgment where the judge's thinking settled upon the view that this child was injured when only one carer was in the house.
Yeah.
And that was a crucial and pivotal moment in the judge's outline of her thinking and the process in which she reached her conclusion. And if one were to turn to paragraphs 79 and 80 of the judgment, which can be found at S515,
7980.
7980,
Yeah.
78, 79, 80, the judge cautions herself about this appropriately. But from paragraph 80 onwards, we would submit that the entirety of the remainder of the judgment is predicated upon the conclusion that only one carer was present in the house. Everything that follows is about the father's opportunities, the 4 opportunities when he is alone in the house. And the difficulty that the Guardian now sees with that line of reasoning is in the preceding paragraphs where the learned judge set out with some care the evidence of the expert on this subject, because the learned judge reached the view that there was only one carer in the house based effectively upon the child's reaction to the infliction of injury and how the reaction to the infliction of injury would have definitely alerted a non-perpetrating parent. And it is difficult, we submit, to see how the judge reached that view in the face of effectively 5 paragraphs, which I'll simply, for the sake of brevity, list for your lordships, which set out the evidence of the expert on this subject. And those paragraphs are 65...
Of his judgment.
Of the judgment, I'm sorry. 65, 69, 71, 72 and 75.
Okay, well, should we just remind ourselves of where
Of course.
they are? 69, 65.
Starting at 65, which is
Dr. Chawler.
Dr. Chawler, the evidence in relation to that is the, forgive me, I've just...
Well, we've read that.
Yes, we've
65,
read that.
69.
69, asked about crying. And this is where she records that the expert said that the change in cry, which is what's important, may be momentary. It's only too easy to imagine that a very brief change in cry, one doesn't know where anyone else in the house might have been or what they might be doing, so that they don't hear a momentary change in cry. It's very brief. And there doesn't seem to be an analysis of the potential for a carer in the house who's not the perpetrating carer missing that, although noticing the escalation in crying. Then one looks at 71. She there is Dr. Chawler, talks about a change in cry even if the baby were already crying. She said that a person who is, to quote her, not right there, may not notice the change in cry. Well, just pausing for a moment, that's very clear evidence that the non-perpetrating carer may miss it. And that's what the expert's saying. But the carer who's the perpetrator would put two and two together and know what they're doing. The distinction is drawn in paragraph 71. And at paragraph 72, later in her evidence, said that a person not observing the causing of the fracture, but in the same house would be aware of an escalation in the crying, but may not know why. And then finally at 75, I have to consider whether B was already crying hard when the fractures were caused him. The cry of pain he would undoubtedly have made with his bones fractured would have been masked or hidden because he was already crying. Dr. Chawla accepted this possibility in relation to a person not right there. This, of course, has already been alluded to. This is a child who, when the leg is fractured, had already sustained multiple rib fractures. And the evidence seems to suggest that this child was crying an awful lot, an extraordinarily a different amount of crying to a child who had not been injured. And indeed, I think there's reference to both parents describing the child as screaming.
And this explains 119 and 120, does it? Or explains why they made findings. Because it's quite significant that the mother is upstairs with the father upstairs, if you're looking at would the person have been likely to hear?
Yes.
But then at 120, having put her upstairs, everyone upstairs, she says that she simply doesn't accept that the mother wouldn't have woken up.
Yes.
And those are it, really.
Those are the difficulties the Guardian has with understanding the judge's reasoning, because there is no attempt made. Of course, we know a judge doesn't need to slavishly follow expert evidence. But if one's going to depart in such a radical way from conclude the opposite of the expert evidence, one would expect an explanation, a full explanation as to why the learned judge did so. And we submit that that is absent in this case.
But the judge doesn't read to me as if she thinks she's departing from the evidence, is the way I read it. She thought she was, save for the extension of the time, the 72 hours, she doesn't seem to think she was departing.
No. And that's a puzzling aspect of with respect, we agree, and that's a puzzling aspect. The way it reads, it does read that way, and it's a puzzling aspect.
So which, could you be precise, please, as to which part of the expert evidence you say the judge went against without, A, went against, and B, without explaining?
The expert evidence was clear that a non-perpetrating parent may not be alerted to the infliction of injury at the time of infliction if they were not present at the infliction, but somewhere else in the house. That the change in cry may be brief, the word used is momentary, and that the crying of this child at infliction may be masked by the child crying not just for other reasons, but because of inflictions of earlier injury. The judge did not accept that because from paragraph 80 onwards, the judge rationalised and approached this case through the prism of the view that a person in the house would have been alerted to the infliction of injury.
Well, it's 120 and 71.
Yes.
Those are the two.
They are.
Right.
I'm very grateful.
So, I mean, that's what my law was asking. I mean,
Yes.
you're saying put 120 and 71 side by side, they don't look consistent.
They don't appear to be so. No.
120 and 71.
Yes, I'm very grateful.
Yeah, 71, isn't it? Yeah. And of course, as my Lord Justice Lewis has said more than once today, that phrase about usual practice carries a lot of weight, doesn't it?
Yes.
It's usually appropriate.
Yes.
Yeah.
I don't want to labour the points about the approach of compartmentalising and not taking a linear approach instead of a holistic approach, because they've been made. With respect, we agree, because the difficulty that arose here is that once the judge had settled upon this view of only one carer being present in the house, everything else had to fit. And there are times when the evidence which was made to fit perhaps should not have done. We submit that this was not an easy case for the judge. There were two carers in the house. There were pieces of evidence which pointed to the mother's guilt, if I can phrase it that way, and to her innocence. There were pieces of evidence which pointed to the father's guilt and to his innocence. It was a difficult case to wade through factually. And all the more important, therefore, we submit, that the holistic approach is taken to weigh in the balance, the evidence there is on the one side and there is on the other hand. The approach taken by the judge in this case, we submit, was flawed. And as a consequence, her judgment remains rationally unsupportable. She took the wrong direction. I think that's a phrase used, quoting the case of Farge in my learned friend Miss Worsley's submissions at paragraph 75. Occasionally there will be cases where this court will be able to identify points where the judge plainly took a wrong direction. We submit the wrong direction was in reaching the view against the medical evidence that only one carer was in the house and then looking at it all through that prism. My skeleton has been brief and my submissions are
Even briefer. Well,
even briefer.
that's-
I don't know if I can assist my lord further. Further.
Thank you very much. Mr. Beckman, just give me a moment, would you, Mr. Field? Just repeat a note. Yes, Mr. Field.
My lord, I hope it won't trouble your lordship too much if I go back to the law, and I know that it's familiar to your lordships, but I just want to emphasise some matters from the case of Volpe.
Yes, well, with the Lord Justice Snowden sat in the case of Volpe. Not that.
Within the Constitution, yes, my lord, yes. And it's important.
Should we get it? Should we open it up?
My lord, yes. If you look at the authorities bundle, page 120.
It's all in the first few, well, I say all.
It's my electronic.
It's the first couple of paragraphs is where Lord Justice Lewis
It is, yes.
talks about.
A118 in the paper bundle.
Yeah.
Lord, can I preface perhaps the submissions by saying this, and this should not be taken as any kind of subversion of the judgment. But the local authorities case is not that this judgment could not have been better expressed. We can see why.
All judgments could be better.
Exactly. We can see why the criticisms which are made are made. But we say that if this court looks at what this court's job is to do in relation to a first instance judge, looking at these authorities, that this judgment passes muster. That's essentially what we say. I'll take you to the more detailed reasons for that later. But it's important to set out, we say, what the guidance of this court is in relation to first instance judgments. And Volpe, in a sense, puts it in the most punchy sort of way, which is why I take your lordships to it. In particular, so there's number one, shouldn't interfere unless plainly wrong. This is under subparagraph 1 of paragraph 2.
Yeah.
Subparagraph 2. Plainly doesn't refer to the degree of competence felt by the appeal court. It does not matter with whatever degree of certainty that the appeal court considered it would have reached a different conclusion. What matters is whether the decision under appeal is one that no reasonable judge could have reached. More importantly, subparagraph 4. The validity of the findings of fact made by a trial judge is not aptly tested by considering whether the judgment presents a balanced account of the evidence. The trial judge must, of course, consider all the material evidence, so it need not all be discussed in the judgment. The weight which he or she gives to it is, however, apparently a matter for him. 5. An appeal court can therefore set aside a judgment on the basis the judge failed to give evidence of balanced consideration only if the judge's conclusion was rationally insupportable. And reasons for judgments are always capable of being better expressed. An appeal court should not subject a judgment to narrow textual analysis. And your lordships will remember I think the quote from Fade, which says that this court is necessarily an island hopping.
Yes, island hopping.
Where a judge has seen the sea.
Yes.
My lord, I put that before your lordships front and centre now, because in my submission this court is in danger of island hopping.
Well, you're right to do so, Mr. Finn, because this is a classic example of a case where we've got to be very careful not to do that.
Yes. My lord, yes.
And rest assured, we will be careful.
Yes. So that's the point I make. And the point is that if you're going to interfere with this judgment, I say again that the question for this court is whether the judge's conclusion is rationally insupportable.
Well, the question is whether that's not quite what the Lord Justice Lewison says. What he says is whether it can only interfere with the basis the judge failed to give the evidence a balanced consideration if the judge's conclusion is rationally unsupportable. That's not quite the same way as you put it.
No.
It's quite a striking phrase.
It is.
Which we've had cause to think about in other cases. That's what he's saying there.
Yes.
The argument is what a balanced consideration. I don't hear Miss Grief's submissions or Mr. Beckler's as quite amounting to that.
No, they say that the judge has taken a wrong direction, that she's narrowed her focus too much by coming to certain conclusions. Indeed, Miss Grief called it a presumption that this injury could only be occurred by one person either being in the home alone or the other person being asleep. The judge is really focusing on the father's case, whether he was ever home alone with the child, and that therefore she has taken herself down a route which is too restrictive and therefore has bled herself into error. But they say so really on the basis of her balancing the evidence and what she shows of the balance of the evidence within her judgment. My lords, I do this with little trepidation because I wasn't there at first instance, and it may be that Miss Worsley will be able to help more with this because she was there at first instance. But can we look perhaps just at how the judge deals with, and rather than island hop through the paragraphs, look at the paragraphs of the judgment in which the judge deals with the 3rd of December. First of all, the crying point, and then how she deals with it in the 3rd of December, because it's been slightly missed, perhaps, that the judge deals with crying in a whole section of her judgment.
Can I just so I understand, before we just get there, just
Yes, my lord.
to pick up the last point that my lord made to you. What Lord Justice Lewison is saying in relation to Volpe, particularly 4 and 5, presupposes that the judge, the trial judge, has conducted a sort of balanced consideration of the evidence. What Lord Justice Lewison is saying is that how the trial judge balances the evidence is preeminently a matter for the trial judge.
Yeah.
And the Court of Appeal would only interfere if the consequence of the balancing exercise is either that no reasonable judge could have reached the end conclusion, or which is a conclusion which is rationally unsupportable.
Yes.
As a result of the balancing exercise. The criticism here is actually, I think, a prior criticism, which is the judge didn't actually conduct the balancing exercise. You never get there because the judge has taken a wrong turn at a prior point, so that she doesn't actually conduct the balancing exercise that Lord Justice Lewison is really envisaging. I think that's, as I understand it, where Ms. Grief is saying, she can distinguish what's said in Volpe and the other cases. It's just that there wasn't actually the sort of balancing exercise that was envisaged in that case. Is that target you're going to be aiming.
I'm very happy to take your lordship's characterisation of the way in which it's been put. Yes, but as part of the argument that's been presented to this court, it is said the judge therefore has failed to balance the evidence properly. But what I'm going to hopefully persuade your lordships of is this, that the judge in this case, with a mass of evidence, has dealt with certain matters as almost preliminary matters. You can see that in the way she sets out the judgment. She deals with the case that the mother makes against the father, which effectively attacks his character in two different ways. There's the medical evidence which she deals with, in particular Dr. Chawler's evidence. She deals with opportunity because she wants to look at the windows of opportunity that there are, and then she deals with crime.
Yes, that's where you wanted to take us to.
And that's where I want to take you to, which is paragraph 73 of the judgment.
Okay.
72.
73.
Thank you.
And I take your lordships to this in answer to the point made. And again, we understand this point, but don't believe it to be right, that the judge has inappropriately narrowed her focus to say that this injury has been caused by someone either on their own or when the other person has no opportunity really to hear what has been going on. And so you can see in I don't want to read it all out, but perhaps I'll ask your lordships to read.
We have read all this. I've got lots of marking already.
Remind us of
Would you like us to read paragraph 73 to where? 79.
73 to the end of 76, perhaps.
Should we just remind ourselves of
Yeah.
what she's... Because we have some of this, but not all of it, earlier. Yes. Stopping at 76?
Yes.
That's all about... We haven't looked... Obviously, we've
There is then, of course,
we've read it, but we haven't discussed the small house evidence up
Yes.
to now.
Well, that is right.
That's
That
what
it's-
you're going to-
this is such a trial judge point that it really needs no further emphasis. That the manner in which this family conducted its life, the house in which this family lived, and the usual way in which this family reacted to crime is very clearly something that the judge derived from the evidence. First of all, she derives crime from medical evidence, she gets it from parental evidence, she gets it from evidence as to the household and so on. So this is very clearly evidence that a trial judge is in far better place to assess than any other judge. And that's where she really begins this notion of saying that if this child were injured in the way that she has been injured, that, as Dr. Chawler said, the reaction to that, particularly in relation to the leg injury, would have been so significant that, in these circumstances, I draw inferences.
Well,
And she draws those inferences when she goes to the 3rd of December. And
before we... Okay.
Yes,
go
my
on.
lord.
You go on. I think you should develop this submission.
Yes.
I'll come back. Where do you go to now? What, the 3rd of... The inference she's drawn the 3rd of December.
So when she then comes to the 3rd of December,
Yeah.
or it's paragraph 118 and following on from there. He says, look, and this is, much of this is incontrovertible in some senses. First at the leg fracture. I'm satisfied that B's leg was fractured by the time the family were at the nearby time on the 5th of December. Everyone agrees that. Both parents noticed he was in pain. Father said he just wasn't himself, and so on. The father had cared for B overnight on the 3rd of December. On the balance of probabilities, I find this was in the main bedroom, changing and feeding him, with the mother in the room. I find that because it was the couple's usual practice. Father said he was very unsettled that night. The mother says not. I don't derive much help there. Now again, that's a judge having heard both parents give evidence and be cross-examined on these points. And again, it's difficult to see how that is criticised. It's said that the judge merely assumes that the father was upstairs with the child. But in fact, again, paragraph 71 to 78, the judge says, well, looking at the way that family acted and that family ran its life, that was the usual practice. She identifies, in fact, 2 nights, 25th and 26th of November, in a different part of the judgment, where father was alone downstairs with the child, because there was clear evidence that they remembered that that was the case. But they hadn't remembered him being in a separate room. Neither the mother nor the father had recalled being in a separate room with the child on the 3rd of December, and so the judge was perfectly...
Well, there wasn't... Sorry for interrupting you.
No.
There wasn't... neither party asserted it either way, did they?
As I understand it, I could be corrected.
He didn't assert that he was in the bedroom.
No.
And she didn't assert that he wasn't.
I don't think so.
The evidence surely was
Right.
the common practice was that they were in the same bedroom on the Friday night.
Yes.
There were at least 2 occasions, one of which thought to be the 9th of November,
Yes.
when the father wasn't in the bedroom. And that leaves the critical question was, could another night have been the 3rd? There was no direct evidence from the parents saying it was or it wasn't.
No.
And the judge has said, I'm going to find that on the common practice. And could she really do that in the circumstances which required not looking at other evidence? Like the time scales would make it very difficult and so on. That's the problem. It's an awful...
Again,
I understand she's entitled to decide what common practice is,
Yes.
but does it answer the problem when the common practice is accepted to be subject to exceptions and nobody knows whether this night was one of them?
Well, it is in the sense that if a judge at first instance is permitted to draw inferences, then the usual practice of the household, particularly when any exceptions have been specifically identified by memory, a judge is surely entitled to infer that since there was no memory that this was different, I infer it was the same.
Somewhere in the judgment there is actually a paragraph that describes the evidence as to the parties gave about where they what they recalled about who was where on the evening of the 3rd of December. I just can't find it at the moment.
94.
Yep,
I think.
Yes.
Yeah, okay.
So
But you see, the common practice wasn't that they always slept there. The common practice was that they usually slept there. But you say they can infer in the absence of any evidence that the common practice occurred on that night. It's a bit of a different common practice, but it's not a common practice of always.
No, exactly. But if one's looking at the balance of probabilities and trying to draw inferences on that standard, then it's difficult to see how it can be criticised with respect. So, just carrying on with these paragraphs.
Yes.
Paragraph 120. I approach this issue with caution, and I remind myself of Miss Grease's warning about the local authorities' argument based on whether the mother heard a cry. But I simply do not accept this mother would have slept through B's reaction to having his leg fractured that night. She had asked the father not to text her with information to go on to that night because that woke her up. The mother is attuned to B's needs and moods. The cry of pain, which I'm sure would have been on the leg fracturing, and then the ensuing crying and distress until he settled, which Dr. Chorley said would have been 30 minutes to 2 hours. That would have woken up the mother, I find, and she would have seen and heard how B was.
Well, that's the paragraph which we, I think Lord Rochester Stone in particular, put to Mr. Beckler, was it?
Yes.
it was.
Earlier, or observed during Mr. Beckler's submissions, that there was a seeming inconsistency with what is said in 120 and what is said in 71.
Well, let's go to 123 in that case.
1, 2, 3.
Because what she says that in 120. In 121, let's go, if we may go to 123 by 121 and 122, because otherwise I miss the point.
Of course.
Even if B had been crying already, which before the fracture was, I'm satisfied the pain cry would have woken the mother, but of course, if he was already crying, less likely she would have been asleep anyway. B's leg would have been immediately painful immediately the fractures were caused. Dr. Chorley said it had been obvious something was wrong, particularly to decreased movement. The initial crying and ensuing crying would have caused the mother to check on B. She frequently got the father to bring B to her when he was crying. The pain that the leg was causing would have been apparent immediately if his leg was moved or touched. And 1, 2, 3 is now the important one. These are the inferences I draw from the medical evidence, from the evidence about how the family lived and cared for B, and the evidence about the mother as a parent. The same would apply if the father had fractured B's leg during the daytime that weekend. The mother would, I'm satisfied on the balance of probabilities, have been aware and would tell me. The fact there is no evidence of B being in such pain like Dr. Childers described from the point when the father came home on the 3rd of December, causes me to find on the balance of probabilities he was not injured after the father came home.
Well, there are points about that sentence. We'll come on to it in a minute,
Yes.
perhaps. But so, what do you submit then from those paragraphs, those sentences you've read out?
That what the judge has not done is mistakenly set herself down an alleyway which she should not have taken. But what the judge has done is look at, and I've only picked out, again, I've island hopped from crying to the 3rd of December, but there is much in between in terms of what the judge says in comment during the passages dealing with opportunity. But she has said, this is how this household was. This is how small the household was, how noise travelled, how the parents reacted to noise, how the mother was attuned to the baby, how the mother would have, I infer, heard a piercing, difficult, loud, shocking cry, pick your words, and ensuing crying for a further 30 minutes to 2 hours, because that is what I find she was like in relation to this baby. Yeah. And I do that, having heard the medical evidence, having heard the parental evidence, having heard how the household was run, and so on. So it's not merely saying, I'm going to find it's the mother, which I don't think is actually suggested, but some coming to a conclusion without any basis and shoving yourself down an alleyway which you shouldn't take. It is a judge who has in fact, albeit she might have done it better, who has in fact identified, here is a crucial part of the evidence, reaction to significant injury. Here is how that applies to that weekend. I do this, I come to my conclusions having drawn inferences from these sources, and the inference I draw leads me to conclude that the mother was the perpetrator. Because, firstly, she would have heard that piercing cry, even if the child was already crying. She would have woken up or was already awake. And if the father had done it on that early morning of the 4th of December, she'd have noticed it the following day. She'd have gone to the child, she'd have checked the child, she'd have seen what was going wrong. And she tells me that she didn't do that.
But, I mean, I understand how you say that she's worked through the inference or drawn the inferences. The question is whether she's entitled to draw the inference that she appears to have drawn from an evidence which she appears to have accepted, that somebody who is, quote, not right there, i.e. a person who's awake but not right there, wouldn't necessarily notice the change in cry. Well, when a leg is broken. I mean, that's the evidence that was given in 71, and
yes.
In fact, it's said again at the end of 75. Dr. Chawla accepted the possibility in relation to a person not right there. And that's talking about a person who's awake, not right there. So how does the judge move from that evidence to a conclusion that a person who is asleep, and as far as we know, not right there,
right,
would have woken up? There's a gap, isn't there, in 120, where she says, I simply don't accept that the mother would have slept through. How does she make that conclusion? I mean, on what basis of evidence?
My Lord, can I answer that?
Sorry, there's a string of questions.
That's all right. You're going to have a string of answers back, my Lord. The first of which is back to Volpe.
Yeah, I knew.
Paragraph 4.
Exactly. That's going to be your default answer to these points, isn't it?
It is, my Lord. Back to Volpe in paragraph 4.
Yeah.
About similar caution applies to a judge's evaluation of expert evidence. Again, it's the judges there in court dealing with all of the other evidence as well. And though, of course, Your Lordship makes a very sound point about an expert saying, a person not there at that point and at that time may not notice,
And awake.
and awake may not notice, it is perfectly open for this judge to say, here is what I find about, because the expert's not asked about that house. Experts asked that question. The judge says, this is how small this house is. This is how thin these walls are. This is how attuned this mother is to that cry. This mother texts the father that the child is keeping her awake crying at night, even when the child is downstairs. This is a mother who does hear, who is kept awake. And perhaps the judge thinks it's most unusual for this mother in that case to say she was asleep all that night, because the father says the child was unsettled. That perhaps that adds to the judge's concern. But what the judge does say is, given what she knows in evidence and having heard both parties cross-examined about these parties, she says, I infer from all of the evidence I get that this mother would have woken up. I don't believe her when she says she didn't. I believe she would have woken up. I believe she either would have woken up or was already awake and didn't go to check the baby and would have done if something had happened to the baby which she had not herself caused. That's the nature of the inferences drawn in paragraph 1, 2, 3.
Did the father give evidence about whether the mother was awake or asleep during that night?
I'll have to hand that over to Miss Worsley.
Maybe perhaps you could just take instructions over the shorter German, Miss Worsley. Don't
Yes,
right now, but
I can. From memory, and I'll check the notes, but I don't think he could recall.
Okay.
He said the baby was unsettled, but
Yes.
he didn't say anything more.
So then my question is, what was the father's evidence about what the mother was doing that night? Did she sleep through it or not? Don't answer immediately, Miss Worsley. I'd like to know your answer after the shorter German. Sorry, Mr. Finn, I interrupted you. So that's. No, I have interrupted you. Have you finished that point?
Yes.
Can I just? The thing about island hopping is that you can't avoid looking at some of the islands as you go through.
Yes.
Inevitably, even if because that's how it works in this court. You don't make a decision on an island hopping basis, of course. But I'm enlightened, and I mentioned. I wanted to go back to the last sentence of 1, 2, 3. The fact that there is no evidence of B being in such pain like Dr. Trawler described from the point when the father came home on the 3rd of December, causes me to find on the back point that it was not injured after the father came home. My question is to you, why could it not also be said the fact that there's no evidence of B being in pain like that when the father came home causes me to find in the balance of probability that he was not injured at the time he came home?
What you have to do in my submission, my lord, is read the words very precisely. The fact that there is no evidence of being in such pain, that is the initial pain of fracture.
I see. So that's an initial pain point.
Yes.
Okay, fine.
Because it's accepted by everybody that on the 4th and 5th at least, this child was unsettled all weekend. I think they say again very unsettled on the 4th and 5th. So it is right to say that there might be a point about overnight on the 3rd, when the father says he was unsettled and the mother says not. Again, that might have fed into the judge's thinking. But the father did say the child was unsettled.
Reliance is placed on the child being unsettled on the 4th and 5th to indicate that by that point he had been injured.
Yeah. By the 5th, definitely.
Okay. But there was no evidence that he was injured on the 3rd. There's no evidence. On the contrary, there was no evidence that he was injured. No sign of him being unsettled on the 3rd. And yet the 3rd is the date when the judge found that he was injured.
Yes. Well, that's, my lord, that in fact does, subject to the timing point.
Well, could I just say...
Sorry. Do you want to just answer that point?
No, if I may,
Forgive me.
my lord, if I may.
Sorry.
Subject to the timing point, that effectively follows the Trawler evidence, as I understand it, which is that the child would have been on fracture, extremely distressed, and have cried hard.
But on movement.
But
On movement,
on movement there would have been pain, but Dr. Chawla doesn't say that initial pain would come back.
No. I don't forget the initial point. I've moved on from the initial point. It's the general point that when moved, certainly, no, not certainly. Ordinarily, when moved, the child would show signs of distress.
Yeah.
And possibly at other times too.
Yes.
After the fracture.
Yes.
And you rely on that, and the judge relies on that, as evidence to support the finding that by the 4th, that's when it happened. But there's no evidence of any pain or distress on the 3rd, which on the judge's finding is when the injury happened.
Yes, but that's why the judge finds that the mother did it before the father came home, so that the initial distress had occurred.
I'm not talking about distress, I'm talking about general distress. I mean,
Yeah.
the child, if you don't know your child's been injured,
No.
you move the child about, to put the clothes on, winter clothes, we all remember. Some of us got more recent practice again, difficulty putting children in and out of winter clothes. That's the sort of time when you notice the child being distressed,
Yes.
moving the limb. You don't expect the limb to be damaged.
No.
It is.
Yes.
And yet there's nothing about that on the 3rd, and there is on the 4th.
No.
And yet the judge found the injury happened on the 3rd.
Yes, because what the judge found about the mother's being attuned to the child, the household, the noise, and everything else, that there was no such report of any such incident on the 4th or 5th, and therefore, if one is looking at when perpetration happened, it wouldn't have happened on either of those days.
I agree. That's how she approached it. I interrupted you. So
Yeah,
sorry.
I just wanted to be asked, could you remind me, please, at what time did the father come home on the 3rd?
About 2 p.m., I think.
It was a
2
2:30 was the judge's finding. It was a
Because-
competent, it was a competent evidence, wasn't it? The judge rejected the mother's pushing it back to 1 o'clock.
That was a leading
That's right.
question, I'm afraid, Mr. Fian, because the next question is, you said we've got to read these words very carefully,
Yes.
1, 2, 3, or we'll get the wrong impression.
I knew I shouldn't have said that.
Yes, because what it says is in pain like Dr. Chawla described, and she's described it up above as 30 minutes to 2 hours, the initial pain, and the ensuing kindness until he's settled. So it looks to me as if it's up to 2 hours before 2 p.m., which makes it 12 p.m. to 2 p.m. You're getting further and further away from the timescale of Dr. Chawla, if we read it precisely, which is the leading.
Yes,
That's why the first one was the leading one. Sorry.
But that's, in a sense, if I say my lord making a presumption that what Dr. Chawla says is meant to be entirely accurate. And that is the difference.
You said that the
That is the
judge's
difference.
words are accurate, and the pain described,
terms
must
of
be the
timing,
up to
my
2
lord.
hours.
In terms of timing, my lord, it really can't be said that a judge must accept that if an expert says precisely 72 hours and no more, which we do not say that is said.
No.
If an expert says that, a judge hearing the rest of the evidence can accept or modify that within reason.
But the evidence then would have to be, it happened sometime before about 12:30, getting
Well,
further
or
away.
if the father got home at 2:30, then up to 2 o'clock.
Anyway, I'm just saying that if we're going to look at it precisely, I just
Yeah.
wanted to get the times right. That's why I was asking, but that's very, very helpful. Thank
Yeah.
you very much.
My lord, yes.
Right, it's now 1 o'clock, so should we break down, Mr.
Lord,
Field?
yes.
We'll resume at 2. Thank you very much.